All right. Good afternoon, everyone, and thank you all for joining us for today's A Month of Service presentation of Wills in Advanced Legal Planning and Why Do You Need It? My name is Nia Murray. I am the Programs Coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. But also included, we have the City of Houston's Department of Neighborhoods, and joining us today, we have Ms. Cecile Carlson. Also, on behalf of our presenting partner, we have Miss Jessie Campbell with Lone Star Legal Aid, who's going to be providing the information for you today on our topic. Also included in our partnership, we have the Earl Carl Institute, Texas Legal Services Center, Houston Volunteer Lawyers, Harris Central Appraisal District, and the Harris County Tax Assessor Collector's Office. And together we make up a month of service. And basically, a month of service is a collaboration of all 8 of our organizations. We come together on a monthly basis, offering a variety of different workshops, resources, and information to the community relative to asset building, asset protection, the maintaining of generational wealth, and community empowerment. We know that there are a lot of underserved communities that are out there that do not have access to a lot of information or don't know where to go for a lot of available resources that are out there. So several years ago, we decided to collaborate and come together and pool a lot of our initiatives together in the hopes of creating a larger platform and being able to reach more people, considering that we all pretty much service the same community. So this particular collaboration has allowed us the opportunity to reach even more people since we've gone to the virtual platform, not only for the city of Houston, surrounding counties, but also across the state and in a lot of instances across the country where people join in to our live presentations or view them on our social media pages or our YouTube channel and things of that nature as well. So do note that regardless of where it is that you are joining us from, that the information that you do hear in our legal service, our legal presentations are relative to the entire state of Texas. It's not just for the city of Houston or Harris County, but it is relative to the laws for the state of Texas. Also note that the information that we do provide is for educational purposes only. It is not to be considered legal advice. However, we do wholeheartedly encourage you all to reach out to our legal service partners like Lone Star Legal Aid, the Earl Carl Institute, and Houston Volunteer Lawyers if you find yourselves in need of any civil legal assistance. And Ms. Campbell is going to go into more detail later on also about other services that are available at Lone Star Legal Aid as well. And then including a clinic that they actually have that's coming up in the next few days or several days or so. In addition to that, we do record our session. We do send out the link of the recording. We also send out the templates and the documents that are going to be reviewed throughout this presentation. This is your opportunity to ask whatever questions it is that you have. We do ask that you try to keep your questions to be as general as you possibly can so that you don't divulge any personal detailed information about your particular circumstance. Because we do record, because we are live on our social media channels, we want to try to protect your privacy as best as we possibly can and ask that you don't do that because we don't want that information kind of getting out there for everybody to have access to. So don't tell us, where you live and who passed and what's going on, all those details. Just kind of keep it as general as you possibly can. If you do, again, feel like you need some personal assistance or more specific questions that need to be answered, then we do encourage you to apply for the services at Lone Star Legal Aid. So if you like, you have the opportunity to type your questions into the chat. And Ms. Campbell's really good about going through the questions as she's kind of going along with the presentation. Otherwise, you can also wait until the end of the presentation and unmute yourself, and then you can ask your questions directly of her as well. If you are joining us on our social media platforms, please feel free to type your question into the comment section. I am monitoring that as well. And I know that some questions were emailed to me in advance, and I'll make sure that all of those questions do get addressed as well too. So there's a lot of information that's going to be covered here today. We do not expect you guys to be the legal experts by the time you walk away from here. but there will be a lot of information for that's going to be covered here. So we want to thank you all for joining us. We want to welcome you. We want to again make sure that you are open to have the opportunity to ask your questions, and do hope that you get the information that you came here to receive today. Um, Again, we know that there are a lot of folks that are out there that do not have access to a lot of resources, or they just don't know where to go when they're in that particular situation. There's a lot that comes to advanced legal planning and preparing for someone's death or incapacity. And we want to make sure that you guys have the most up to date, the most relevant information as it relates to our state and to our area. We know that there's a lot of people on the street committee out there that's kind of giving their own advice, their own information. People are relying on social media to give them information that is not actually accurate or relevant. So again, we want those legal experts in those fields or in those areas to provide you with that information. So that's what we're here to do today. So without further ado, we're going to go ahead with our introductions, and then we're going to get started into the presentation. So Ms. Cecile, would you like to introduce yourself?
Sure thing, Nia. Thank you. Good afternoon, everybody. My name is Cecile Carlson. I'm one of the outreach coordinators here at the Department of Neighborhoods, and we are one of the partners in the AMOS collaboration. Super thankful to our presenting partners. Super thankful to Ms. Jessie. She has a wealth of information, and I'm excited to go through the material. Like Nia said, make sure to ask questions, take notes, and pass along this information if you know somebody else who might benefit from this. We do have our pre-recorded sessions. Also, this one you can also share with them or invite them to our next session. And then I'll just kind of make my plug real quick. We have a resource fair coming up October 23rd at the Palm Center of Business and Technology Center over at the OST South Union area. We're going to have some of our partners from AMOS be there in person. So if you want to get a chance to meet us, talk to us, or maybe apply for services, we'll be there again Thursday, October 23rd from 10 to 12. And that the Palm Business and Technology Center is located at 5330 Griggs Road. 77021 is the area code or zip code. And I'll go ahead and pass it on to Ms. Campbell. Thank you all so much for being here.
All right.
All right.
Good afternoon, everyone. My name is Jessie Campbell. I am a directing attorney with Lone Star Legal Aid, and I'm really excited to be here this afternoon to chat with y'all about legal advance planning, what it is, and why you need it. And so first, let me let you know a little bit more about Lone Star Legal Aid. We are a civil legal aid program. So what we do is we do provide free legal services to eligible households. Eligibility is based on the household income and the assets and the size of the family, but it is based on that piece of information. And we serve on civil legal matters, which includes a variety of different topics, in addition to wills and estate planning and probate that I'll be talking a little bit about today. We also do things like family law, housing, employment, consumer matters, just to name a few. You can see on your screen the list of all the different types of topics that we cover. We are covering up to 76 counties, 72 of those in the state of Texas and 4 of them in Arkansas. We cover the eastern third of the state of Texas, so all the way down from Galveston to Texarkana, and we go as far west as Waco, and then of course to the border of Louisiana is where our service area is. So if you know people in there who need our services and who may qualify, you can definitely refer them to us. I also like to tell people is I don't assume that you don't qualify for services. Again, it's based off of size of family, income, and assets. It's a pretty complicated mathematical problem that they have to kind of solve with all the information that you provide. And it's actually a pretty solid number of people in the state of Texas that do qualify for services. So if you think it's possible, go ahead and apply if you need our assistance. All right, Ms. Nia already told you all of this, but just as a reminder, this is for educational purposes only. I am not your attorney. I am not providing you with any legal advice today. Everything today is informational only. It's going to be talking about the law in big picture, like what everyone needs to know about this area of the law. But I cannot answer any specific questions. So as you do have questions and you want to put them into the chat for those of you watching with us on Zoom, be sure that you're not putting any private information information in there because one, this is the internet. We don't want anyone having private information out in the world about you, but also I can't answer it more likely than not. So because sometimes we start going into the land of advice and I need you to apply for services before I can do any of that. But of course, feel free to ask your questions, put them in the chat for those in Zoom. For those of you watching on our social platforms, as Ms. Nia said, you can go ahead and put them on there in the comments, and then we will we will circle back to them when it's the right time. Either Ms. Nia will interrupt, put in a chat for me, or we'll do it at the very end. Okay. All right, well, let's get going. So today is part one. I do this in two parts, and today is the first part, which is to give you a general understanding of what is advanced planning, what is estate planning, what a will is, and what do all these documents do. It's a lot more than just having a will to be prepared for what's going on, right? So today we're going to be talking about the general principles so that you can walk away thinking about what documents you need, what kind of situation you have, and how you may be approaching those issues, and when you either work with an attorney or if you choose to write documents yourself. Estate planning covers three kind of areas. The one is on death. That's what most people think of because they think of a will. They're thinking about, what do I need to do to prepare my family in the event of my passing? And so we are going to be talking primarily, most of the conversation today, we'll be talking about death and the documents you need to prepare for that. Incapacity, this is the inability to make decisions for ourselves, whether it's temporarily or permanently. How are we going to make sure that we have the right people in place, what documents we need to have, so that way when people are making decisions on our behalf and we are not able to do so, that we're picking the right people and empowering them with the right types of powers that they need. And then we will be talking about long-term care very briefly. That in of itself is a pretty big topic and that needs to kind of get covered probably in its own presentation. But it is part of advanced planning. We are an aging population. We are living longer, which is fantastic. But as we live longer, there's more likely going to be a need for long-term care. The estimate is around 80% of all Americans will end up in some form of long-term care residential facilities or needing long-term assistance in their own homes. And so there's some things you got to be thinking about in terms of preserving your assets and making sure that decisions are put into place to allow the long-term care to happen when the time arises. And then lastly, we will talk about some available resources very briefly on like what to do next after I give you all this information. All right, so first up, we're going to talk about the difference between advanced planning and estate planning with probate. Today, we are talking about advanced planning. We will not be talking about probate. And so while I am part one today, part two will be next month, which is about how to draft your own documents. There is a sister, an accompanying piece, a third, if you will, that's going to talk more about what happens after a person passes away. And that's the probate process, clearing title to home, and some other issues that kind of happen after a person passes. That presentation is next week. You will have that in your calendars from NRCDC. Sign up for that. But I will not be talking today about the probate process, except to the extent of what we're doing right now, which is so that you understand what probate is and what it does, because it does impact what you do with your advanced planning. So today it's going to be like, this is what you need to know, what might happen and what you can do about it, as opposed to this is what happens now that person has passed, right? So advanced planning is what it sounds like. It's planning and preparing for death, incapacity. In the event of our death and incapacity, the care of any minors or adults who are disabled adults in our own care, as well as long-term care. That's I already mentioned that. And putting all of that planning into a legally binding written document. That's what advanced planning is. It's preparing. It's before. Probate's the after. A person has now passed, and now we have to do something. It's the process of handling the estate after a person passes away, and that includes a court procedure, typically. And so you will be filing an application in a probate court in Harris County, in counties outside of some of the other counties, and maybe a county court that you would be doing that. It just kind of depends on the county, how big the population is, what type of court you would be filing it. But the process is generally the same, regardless of what the court is. It's going to be paying off the debt of the estates and conveying property ownership if necessary, and then managing issues for individuals under legal care, like coming up, who's going to have custody, who's going to have guardianship. What happens in that court process very much depends on what advanced planning documents exist. What type of will do we have? Do we have a transfer on death document? All of this stuff we're going to talk about later. So this is where, so that's what the issue is. So that's after. Now, I don't have, this is talking about death, but it's also the same for a guardianship. If in the event of a permanent incapacity, there is a court process to establish a guardianship. And similarly, it's the same thing. There's an application that's filed in the court. There is a determination of what the assets are, what the needs are, and then appointing a guardian to be able to take care of the affairs of the person who is fully incapacitated. Okay. So a key takeaway, I'm going to give y'all some key takeaways today, but in this first part is we're going to start at the end, which is that something must be done after a person passes away. And that typically is something is you need to talk to an attorney. What's one of the things when it comes to advanced planning is that we are kind of preparing under a hypothetical situation. We are typically, when we're writing our advanced plannings, whenever we're doing it, right now, we are looking at our current situation and drafting for that current situation. And I'm going to talk about how you update it and things like that. But it's typically going to be like, well, I own a house, I have minor children. And so I'm going to make sure I have the documents put into place that kind of fit the current situation that I am in. But we don't know what's going to be the situation when we pass. It could be 10 years from now that the person passes, and then there's been some other changes in the property that's owned, and maybe there's something else that pop up. There's a debt that didn't exist at the time that the will was written. And so there's some different things that can kind of happen. And so you need to go talk to an attorney to be sure that whatever the next step is, it may be nothing. It may be that all of the estate planning that was done in such a way that nothing further is needed, and other than for the attorney to say, okay, this is, you need to file a death certificate in this county, and that's it. That's all, but you don't want to miss anything. And that's one of the things you will learn in next week's presentation about probate and what happens after a person passes when certain documents are not in place. It can make things difficult for our heirs. But you do want to just say to whoever needs to know, please take these documents to an attorney and they will let you know what the next steps will be. So when you're doing your own advanced planning, it's very important to realize it's an individual plan. It's what works for you, your family, your dynamics, right? So it's going to be also affected by the type of property that you own. Do you own a house? Is it paid for? Is there a mortgage on it? Did you inherit that house? Is there more than one owner on the property, right? So it's going to kind of be the type of property that we're going to be looking at as well, because that can make a determination of what's next and what needs to be done. Who is inheriting? Is it going to be a minor children, an adult living with a disability? Is it a spouse but there's children from a previous marriage? So there's different factors that we have to take into account on when they're inheriting the property. And so I did put this as an example, which is, do they have special needs to be taken into consideration? One of those has an example is if you're an adult living with a disability and the disability prevents you from being able to work, you may be receiving supplemental income from Social Security because you are unable to work. Well, depending on the inheritance, that inheritance may disqualify the individual from having their disability assistance. And well, we don't want the heir to lose their benefits. And so we need to think about what property are they going to be getting, and do we need to do something to make sure that we protect the benefits, because it's not very often that the inheritance that individual will receive will be able to completely replace the Social Security income that they're receiving. And so we want to think about that, right? Like make sure we're not harming our beneficiary by giving them something in the will. Health conditions. We are going to be talking about medical preparation. What is your health condition? Is there something that happened? Do we have a prognosis that we're thinking about that is going to impact what we put in our documents and how we draft them, as well as long-term health conditions? We may be perfectly healthy now, but maybe we have a family history that we anticipate. I mean, we hope that medical science has gotten to the point where we don't have to worry about potential genetic illnesses that may be in our line, but sometimes we know for a fact, like it's like, well, I hope I don't get ill, but like my grandfather, my father, and they both had X illness, so I'm going to plan that I might get that around the same time when they got it. Hopefully we don't, but we're going to go ahead and think about what we do in the event we might have that as part of our future. And the thing that I always want to say when it comes to the individual plan, the reason why we talk about this is because not all wills are one size fits all. Not plan all plannings are not one size fits all. So I'm going to talk about some forms later on and some templates that exist that you can use, but it doesn't mean that it's the right document for you, right? Just because your neighbor looks like you have the similar house, you're both married, you both have children of similar ages, and they have paid an attorney or they've done their own estate planning. They're like, oh, buddy, here, you can take a look at ours and just copy it. Just, plug and play like what's yours versus instead of what's on ours. Well, the thing is that if they did hire an attorney to do their documents, there might be things that you don't know about their family dynamics, the debt that they have, the type of property that they own. And even though it may look the same, it may not necessarily mean that that will that was written for somebody else is going to apply to you. The same is going to be true for some fill in the blank wills, these templates that exist. Although we will be sharing templates with you, it's always be cautious. Always, just because a template is available doesn't mean it's correct in your situation. That's all it is. It's a template. It's a guide. It's a place to start to know what to do next. And sometimes you can use the template as is written. Sure, maybe. But sometimes you need to do something a little bit different. So that's why I really focus very much on this individual plan, because I don't want anyone just thinking, oh, just because this exists or I can get a copy of this, that everything is going to be great. It's estate planning, while for many people can ultimately be very simple documentation, the process of figuring out what needs to happen in that documentation can be complicated and has a lot of nuance to it. So when to update? I always say that as soon as you realize that certain things are inevitable, that being death, that's nice the time to have a will. And when you turn 18 years old. So I am a firm believer that everybody needs a will. And you're going to hear me repeat that multiple times. Everybody needs a will. I do not care if you have a trust. I do not care if you have a transfer on death document. I do not care. Everybody needs a will. And I'm going to talk more about that as we go. It's better to have a will and not need one than to need a will and not have it. So as soon as you are aware that a will is necessary, that documents are necessary, that's the time to write it. But otherwise, what you're looking at and when to update your documents or take a look at, see if they're still good and still do what you want, is when there's major life changes, is kind of how I describe it, right? So marital status, any change in marital status that would include marriage, separation. You're not legally, in Texas does not recognize a legal separation. So just because you don't live together and you haven't lived together for 10 years does not mean, according to the law, you're not married. So on separation, a divorce and widowhood, remarriage. So any change in marital status, you're going to want to take a look at your documents, make sure it's doing what it's supposed that you want it to be doing. Children, changes with children. That includes obviously the birth of any children. Hopefully no one experiences the death of children. It also will include the age. Are they aging up? Have they turned 18? If they are over the age of 18, are they living with a disability? And what type of disability are they living with? So those are going to kind of be the times that you're going to be looking at your documents, making sure that things are kind of still in line for your children. Health changes. I kind of touched a lot on that in the last slide, but of course, if your health changes and you have a prognosis, you may want to take a look at your health documents to make sure that they are what they are supposed to be. And depending on what that prognosis is, obviously, your preparation documents for death would also need to be reviewed. And then major property changes. This one is big. Typically, it's not, I don't want to imply that like it's any property change, right? Like but it's gonna kind of be like for sure if it's property for which there's legal title to it. There's a legal piece of paper that says who owns the property. So what is that for most people? For most people, it's going to be house, land, cars, a boat, RVs, so things like that you buy where there's a piece of paper that says, yes, I am the legal owner of this property. That's where you're going to want to take a look at your advanced planning and make sure that the documents are what needs to be, or if you need to do some new documents for those major things, right? But it also can include property that isn't titled. It could just be really important or sentimental or something of financial value that you may want to include in your will or in other instructions. to make sure that's going on. So things like if you're a person who inherited grandma's pearl necklace and there's a family tradition that that pearl necklace goes to the eldest granddaughter, well, then you have an obligation, in theory, a moral obligation to make sure that your will has the grandma's, and great grandma's pearls going to the eldest granddaughter, because that's the instruction and you want to go ahead and include that in your will. So things like that, you're also going to want to take a look at, make sure that the document is saying what it needs to say. I do drink during these presentations, so bear with me when I have to do those. The next thing to think about before we go into any of these documents, every single one of these documents has a person that you are naming to step into your shoes. They have different names depending on the document, an agent, an executor, but the role is effectively the same. It is a person who is stepping into your shoes and making decisions and doing actions on your behalf when you are unable to do so due to your own passing or your incapacity. Nice little chime there. So when you're thinking about each of these documents, you're going to want to think of the person who's the best fit for that role. And sometimes it's someone that's obvious and sometimes it's not. The person you're going to select is someone you know and trust who will do what's in your best interest and the best interest of your estate, or as you would make those decisions. That one actually can be kind of complicated, right? Because sometimes it is loving decisions, right? I'm not saying that these are like fights or things like that. These are loving decisions, but just a difference of opinion. And so you want to be sure that you're picking someone who understands what you would do, who understands what you want, and to make the decision as you would make it, not what they would want for you, but what you would want for you. And so you got to sometimes pick that. It may not always be the natural choice. For example, for when it comes to will, you're naming an executor. That's the person who's responsible of handling the estate. Um, some people will not choose their spouse. And, if it's a couple that have been married for 50 years and now they're updating their documents, well, the spouse may not be, although they trust their spouse to make decisions and everything like that, they might not be the right choice for that, right? Because they would have lost a life partner, someone they've been together for, probably more than half of their life at this point in time. They're going to be grieving. So maybe the better choice would be, a child, an adult child who would be able to step into that place, or a sibling, or somebody else that might be able to take on that role. I am going to talk a little bit more about what the executor does to kind of help that, but you're going to kind of be thinking about what those decisions are. Um, this is what I say, it's work, right? Like when we're talking about handling an estate when a person passes away, it's a lot. It's working with an attorney, it's making sure that things are being done, it's drafting paperwork for after a person passes away, depending on how old they are, it's preparing a tax return, the final tax return. So these are, writing a draft, selling a house, like it's actually work, right? And so, not saying that it can't be your spouse or a child or anything like, but maybe that's not the right person. Maybe you want to be thinking about somebody else who can come in and take on that position to be able to kind of help the family while they're grieving and learning how to live a different life now because the person they love is no longer with them, and then let somebody else kind of handle the day-to-day work. We do recommend that you select one person. It is possible in some of these documents, not in all, but it's possible in some of these documents to have more than one person be in the position. I recommend against that. I don't. I think it's highly discouraged because you are doing these documents for one of the reasons is to avoid conflict and avoiding, well, what do we do types of things, right? So that's kind of the thing. And if you have two people and they disagree on what they should do, well, then who's going to be the final decision maker? Who's going to be the one doing that? And it could potentially, depending on the scenario, a third party. It could be a judge, could be a doctor, right? There could be somebody else coming in and being like, well, I got to make a decision. And we're going to have this person who's not part of the family, who's not part of the dynamics, who understands everything, coming in and just kind of making a decision based on what the law allows them to and based on their own interpretation of the facts as being presented to them. And and it could not be that they're right. Like, just because they disagree doesn't mean they're one is wrong, right? So, for example, on a medical power of attorney, one person may say, I really think that this experimental treatment would be a really good treatment for our parent, and I really want them to give it a go, give that a try. And, that's loving, right? It's trying to find a cure, it's trying to find treatment, but then another person may be like, no, I don't think that our parent would want that. Our parent has always said that if they're going to be in a possible state of incapacity where they're where they're in a coma and they can't survive, and like they don't want that. They want to go ahead and be allowed to pass peacefully. We should let them pass peacefully. That is also a loving decision based on their understanding of what the thing will, what the person would want, right? What their parent would want. So again, but now who wins? Who gets to decide? So pick a we recommend you pick a person and pick an alternate. The analogy that I heard once before, and I think is a great one. Do you really want two people driving a car? And if you don't, then you shouldn't have two people driving the estate, driving the medical decisions. You just want one. Discuss this decision with the person. Make sure that they know that they've been selected, because if they don't know and it's all of a sudden a surprise, they may not want it, right? And so be sure that they are prepared to do it, that they want to be able to take on the role if necessary. It's a responsibility, right? Like you're asking somebody. I don't know if you've been asked. Think about it, if you have been asked to serve in that role. It's a responsibility to be like, okay, well, I got to make sure that I get the right assistance. I'm talking to the right doctors, and I'm doing the things that need to be done. And so, but have a conversation with that person to be able to say, this is what I would like. I'm going to go over my will with you so that you understand what I was thinking when this was written, what I told the lawyer. So that way, if there's any questions, you will have an idea and you will already know why I did what I did. Let's talk about medical decisions. This is what I would like. I want to be kept alive, and I'm not ready to go. Just go ahead and do everything. Or it's kind of like, I'm okay with, letting me pass peacefully. And that's kind of like towards, those are big decisions, but it also could be things like, I don't believe in blood transfusions, or, things like that, right? Like, but have conversations about some hypotheticals and what you would like in those situations and explain that to them so that way they're empowered. I already mentioned that you should have an alternate, or every one of these documents have an alternate, have the same conversations that you have with the primary. So that way they can also tell you if they don't want to have that responsibility. What's not on the slide is the counseling side of things. Have the conversations with the person that you didn't choose, the natural person who's going to be, that they think they're going to be the one chosen, but you want someone else to serve in that role. When you're not available to answer questions, people just will create stories in their own mind about why. It's like, well, did mom not trust me to be able to do this? I thought that she realized that I would do anything for her and I would take care of her. And why did mom not pick me? Right? And then mom's not there. Mom can't explain why the decisions were. And so you don't leave that up to that, right? Just be like, hey, honey, this is a loving decision on my part. Remember, an executor has to do all of this work. They have to work with a lawyer. They have to go to court at least one time. And then they're going to have to try to sell the house and fix up the house. You're my best friend. You're my number one, and when I'm gone, you're going to be sad. You're going to have to learn to live without me. And let Uncle Bob, who's the accountant who loves you, this is his loving agreement. He's agreed to do this so that way you and the rest of the children can start to live a new life, learn how to live a life. Focus on that. So that, he goes, let this be a gift from him to you in this difficult time. So have those kinds of conversations with those people so that way they're not caught off guard when they're not selected. All right, now we're going to move to talking about the death documents. We're going to start with wills. Everyone needs a will. Again, I told you I was going to say it more than once. Everyone needs a will. It's better to have a will and not need it than need a will and not have it. And here we're going to talk about some examples on why that's important. So the reason why I get people who say, I don't need a will, it's usually a misunderstanding of what happens when a person passes away and what is required as it relates to their property. Everyone owns personal property. So one of the things I always hear is, I don't own anything. I don't have a house. I don't have a car. I own nothing. Well, yes, you do. You have your own personal property. You have your jewelry, your housing, your furniture, your clothing, antiques in your household, maybe, right? You own something. Don't diminish the value of sentimental property. Some of my favorite things that I have for people who have passed are a childhood doll that my great grandmother bequeathed to me in her will. Very cherished. It's not worth anything, but it is worth of something to me, right? And something to her. And so it's like, so everyone has personal property. And so even if there's nothing sentimental, if you're like, I don't got any of that, like, like you told me about that, I don't have that, right? You still have it though. If you're living someplace, who's allowed to come into that property that you live at? Who's going to get and they're like, all right, they're just going to sell it. Well, okay, so there's an estate sale. Who's going to get the proceeds? Who's going to get the proceeds of the sale, right? If you're not, and who's allowed to come into the rental unit? Not anybody can just walk in. A landlord can't just let somebody walk in the door and take stuff out. So those are the types of things. You still need somebody to have the authority to come in, take care of the property, and do what they need to do. And also, you're still going to have final expenses. So while you have everyone has personal property, there's still going to potentially be final expenses, funeral arrangements, final medical bills. Those are things that are, paying the last utility bill, right? Those are things that still need to be done. Who's going to be the one that's going to be able to handle the things that need to handle? And so just be aware, just because you think you don't have anything doesn't mean there's not a need to have a will to be able to deal with some of the stuff that has to happen. Someone must have the authority to distribute the property. I already talked about that in the sense of a rental property. Someone's got to be able to come in and have the estate sale of the property. So they will need those instructions on what to do and what's going to happen, especially when it's about your house. And for sure, I already talked about you need documents if your title is your property is titled. And so that being said, title property must go through a legal process to clear the transfer, to clear the title. If you don't do something, then what you may have is a cloudy title. What is a cloudy title? It just means we're not sure who owns the property. At its base core, that's what it means. We don't know who owns the property. And so you have to go through a probate process for real property for your house to find out who owns the property. Or we're going to talk about a transfer on death option. That's another way to kind of solve it. But it has to go through some type of a legal process. Otherwise, you may have that. What does cloudy title do? It can have significant impact on your beneficiaries. It can diminish the value of the property. What if they want to sell the property and now someone's going to be buying it subject to a cloudy title? Unlikely. Likely there's going to be a legal expense to have to go in to kind of fix the title, to fix the cloudy title. It can diminish the value. All of a sudden, you may have 10 people who own the property that you didn't intend to have 10 people own the property because you didn't have a will, but 10 people under the current state of the law says that they own the property. Well, again, that diminishes the value of the property. And so I always like to tell people our greatest wealth for the majority of Americans, like 95% of Americans, is like in our homes. If we are fortunate enough to have been able to buy a home, that is typically where our generational wealth sits, and that's where our equity sits. And that is what we want to pass on to the next generation and to our next person. And so having a will and having a right document in place protects that equity, protects that generational wealth to go to the next generation. In Texas, verbal agreements are not enforceable. So I get things, we got a plan. We agreed. We talked about it. Great. Put it in writing. Because one, you can't enforce it. Two, you may be walking away from that conversation with a very different understanding from the other person. Because just because people are talking, like, right, we've all been in those conversations where later on we're like, wait, what did you think I meant when I said X, right? And so you want to be sure to say that this is important, right? These are important issues around property. And so you got to put it into writing so that way it is enforceable and that it's clear. It's like, okay, we made an agreement. This is what the will says. Okay. You understand. We agreed. This is what we talked about. Right. And so, and then of course, then it makes it enforceable in the event there is a conflict where someone comes in and is like, well, no, that's not what we agreed to. It's like, well, yeah, but I put it in writing and you said this is what we agreed to. So just be sure that things like that get put into writing. Another final misconception about property, just because you own property together does not mean that the other person gets the property when you pass away. There's a lot of misconceptions around that, particularly around community property. We are a community property state that says that any property that we purchase while we are married is owned by the couple, by the community, and except unless it's made separate property or it's inherited, then it is separate property for the beneficiary. And so, but the reason why this becomes a misunderstanding is because in some instances, when there isn't a will, and it passes under intestacy law, that's basically the law when there is no will, intestacy, that if you are married and your children are the children of your surviving spouse, then your spouse is the beneficiary of the estate. That's what it says under intestacy law. And so that's where the misconception comes into play. It's like, well, because they may know somebody that happened and then their spouse was the person who got the property. But what happens if we are talking about a second spouse? So we have a person who's been married, and there's children born of that marriage, and then now we've married Barbara, right? And right, well, second spouse Barbara is not entitled to that property under intestacy laws. It's the children. They get the half that belonged to their parent that passed. So you just kind of want to be sure that we are looking at that. And then, because it may not actually happen. And so if you want that to happen, that you want Barbara to inherit the property, then that needs to go into a will and make sure that it's clear what to do. All right. So what is a will? A will is a legal document in which a person called the testator writes down what they want to happen to their property and debt. Together, the property and the debt together are called an estate after their death, and who they want to manage that estate. That's the executor, the person who's going to kind of take on the legal responsibility to handle those finances. And it covers only probate. Now, I am not going to go today into all of the different parts of a will, what needs to be included, things along that lines. Today is just kind of talking about in a high level. Please come to part 2, because in part 2, when we talk about drafting a will, is when I really talk about what needs to be included, how you need to include it, thinking about the different property and things along that line. So please plan for that. It's also recorded, and you can go watch a previous recording of it as well. But so just be aware of that. But if you do have questions about a will, just let me know, and we can try to cover some of that today, depending on how in the weeds we go. But otherwise, it's just that document. It's just a will properly executed and drafted. And I am going to talk a little bit about some wills later on, but not too in depth. Probate assets is what gets covered in a will. So what's not covered in a will? Those are non-probate assets. So a non-probate asset is property that is owned in such a way. This is our folks in Austin or in DC that they said if property is owned in this way, that ownership transfers to a specific person without going through the probate process. So it's not a way to avoid probate. It automatically avoids probate. It's just the way that the property is written. So those for most people include retirement accounts, your IRAs, 401ks, 403bs, right? Your retirement account. When you have a retirement account, you're going to go to the financial institution where that account is held, and you're going to name a beneficiary. You're going to complete a form, submit it to that financial institution with the beneficiaries listed. Life insurance proceeds, same thing. You're going to designate a beneficiary. You're going to name who the beneficiary is. You're going to submit it to the policyholder, and then you will be able to do that. Payable on death accounts. So these are with your financial accounts, like your checking accounts and your savings accounts and banks and credit unions. So payable on death accounts, you're going to name a beneficiary. And how that works is that you're telling the bank or the credit union, hey, upon my passing, this is who I want to get the property, right? And that is designating a beneficiary. For those 3 types of things where you're designating a beneficiary, what happens for the beneficiary? They're going to contact that financial institution. They're going to submit a death certificate, complete whatever forms is required by that financial institution, and then that financial institution will process everything and transfer the funds according to the beneficiaries identified by you as the account holder. And so be sure when you're updating your wills and major life event has happened, and so you're updating your will, be sure you're updating your non-probate assets. Be sure that your life insurance policy has also been updated. It has happened. It has definitely happened where life insurance proceeds didn't get beneficiary wasn't updated. It was for first spouse. Well, first spouse got the money even though there was a second spouse, right? So you got to be sure that you're kind of updating those as well. The last option here is a joint tenancy with a right of survivorship. This is where that situation we're talking about, just because you co-own it doesn't mean the other person gets it. This is the one where it does. You will create a joint tenancy with a right of survivorship. In that case, the two owners of the property, when one survives, the survivor gets that property and doesn't pass according to the will or intestacy laws. Be very conscious about this. This is not the default. This does not happen in Texas. In Texas, the default is that you own what is called an undivided interest. So you own your percentage of the property, and you can pass your percentage on to somebody else. So you have to create a joint tenancy with a right of survivorship for that, be able to do that. You may want to consider talking to an attorney about it. There can be unintended consequences that you may not be thinking about, and to be sure that you're doing what you need to do. Once it's created, it's very hard to uncreate it, and to undo that. So before you do that, you may want to consider thinking about making sure that you've seen behind all the corners, and some of the potential pitfalls of doing a joint tenancy with a right of survivorship. That's it. Everything else is a probate asset. So a car, a house, clothing, the rest of it is all considered a probate asset, and that is what's going to go into a will. If any of the above, the retirement accounts, life insurance proceeds, payable bank accounts, if they don't have a beneficiary listed, then they become the property of the estate. And that's where it's going to go into the estate. And this is where having a will really matters, right? It matters all the time. Probate is so much easier when you have a will. But the thing about that is that, like, all of a sudden that's going to go into the estate. And I have had situations where we had to go through a probate process where the only asset was a life insurance policy that did not have a named beneficiary on it. And it took years. It took years to clear that up because of the way that the process works in probate when there isn't a will. Like we had. So you don't want that to happen because you got it in order to serve your beneficiary. But let me go through a process right now. Let me kind of explain what happens when it comes to this, for the non-probate assets. So we're going to use life insurance, but it's going to basically be the same for all of it. So we're going to use life insurance. You name a beneficiary with a $50,000 life in policy. You name Bob to get the policy. Upon person's passing, Bob's going to submit the documentation to the insurance company, and they're going to submit a check for $50,000 to Bob. So that's what happens. All right. So now we have a life insurance policy of $50,000, but Bob was not named. Bob's not named as a beneficiary under the life insurance policy. But there's a will. There's a will that names Bob as the beneficiary of the policy. Well, Bob's got to go hire an attorney, and he's got to go to probate court. That's the only asset is this $50,000 policy. So the insurance company is going to write the check to the court on behalf of the estate. The estate is now has $50,000 in its assets. Bob has hired an attorney, again, like that. Well, now he's got to pay the attorney. He's got to, pay the court fees, whatever it is, right? Let's pretend that that's $5,000. I have no idea how much it would cost. $5,000. Pretend it's $5,000. Now we finished the probate with our well-drafted, properly executed will that names Bob as the sole beneficiary, and we got $50,000. And now Bob will inherit $45,000 because of the $5,000 that got to be spent for the lawyers and the fees and things like that. Well, right, the better thing would be for Bob to have been named on the life insurance policy, so that way he got the full $50,000. He's out $5,000 now. What happens now if there's this life insurance policy and there's no will? Oh, you're going to tell me, oh, well, Bob's going to get it, right? No, I didn't tell you what Bob's relationship is to the person who passed. So let's say that Bob is the only child of the person who passed, and person who passed, and the parent was not married, or a widower, right? And so Bob's like, well, of course I'm the only person who's going to inherit the property. I'm the only child. Are you, Bob? Are you the only child? What if there's a secret second marriage, a second family? What if there was a child before in the previous, and being raised by somebody else that you don't know about? So same $5,000 has got to be spent for the lawyer that had to be hired, and all the paperwork that had to be done. Now, without a will, that lawyer now has to do more work. Like, it's not as simple, right? So now that lawyer is going to have to increase their costs, right? It's like, well, I'm sorry, because there's not a will, there's a lot more work involved with the probate process. I got to do a lot more. So instead of like the $4,000 that I charged you for it, I need to charge you $7,000, right? And so now we have, a full $10,000 being sent off already. Well, the court might require an ad litem to be appointed. What's an attorney ad litem? That's a person who is the lawyer representing the unknown beneficiaries because we don't know if Bob's the only child. So this ad litem is now going to go and search and find and do research to make sure there isn't another relationship that the parent was not married and like so it's going to do all this work and be able to do that. Well, guess who has to pay for that? The estate has to pay for that, and that person is going to charge $5,000, right? So we have our $10,000 that for the lawyer we had to hire and the court fees. Now we have $5,000 that we had to spend for this ad litem, and now that $50,000 benefit has turned into $35,000 for Bob, poor Bob, right? So that's kind of pushing in that idea that it's better have a will and not need it than to need a will and not have it, right? So, but first you're going to want to update your beneficiaries on all these accounts. But if you don't, you're going to want to be sure that you have a will that is pretty well drafted, and so that people understand. So that way, in the event that something does have to go to court, it's pretty safe. Now, I'm going to let you know why you need to do that. I've also had a client show up, several years after a person passed away and they didn't have a will. They didn't even know there was a life insurance policy. The life insurance policy was purchased by their employer, and as part of a benefit that the person who passed had as part of their employment. And now there's no beneficiary listed, and now we had to go through this very complicated probate process for intestacy. Um, So, the next takeaway from that to kind of let you know is to be sure that people have access to the bank account. I always recommend, regardless of anything else, you should really think about having a person be a designated beneficiary for a bank account or make them a co-owner on the bank account so they can get access to it. The average length of time for a person for probate to begin for people is around 4 months after the passing. Um, Obviously, some people do it quicker, some people do it later. But in the meantime, of those 4 months, the bills still have to get paid. If there's a mortgage, the mortgage has to get paid, the utilities have to get paid, funeral expenses need to be done. So I always encourage people to have access to the bank account in some way. Beneficiaries, so that way they can get access to it. And for a lot of people, there's three things that is our primary property that will almost certainly require a probate: our house, our car, and our bank accounts. And so if your bank account is a payable on death account or has a joint owner on the property, then that bank account doesn't have to go through probate. And so, but also making sure that people have access to be able to pay the bills. I always say, you'll hear me say it all the time, if you're going to make a co-owner on the account, be sure it's somebody you really trust. There's always a concern of potential abuse and theft by co-owners on property. So, you got to be mindful of that. I wish I can tell you that I've not had situations where, unfortunately, a child has done something, not great for their parent by stealing property and doing things along that lines, right? So be very careful of that. They don't have to be a co-owner. It just could be the easier thing to do, but it doesn't have to be. It can be a payable on death account. Okay. Now we're going to talk about types of wills and go a little bit into the probate process a little bit at this stage. There's two types of wills in the state of Texas. The first one is called a holographic will. That is just fancy legal language saying a holographic will is 100% in the testator's own handwriting. This is signed and dated. So you're going to take out a piece of paper. You're going to find yourself a nice blue pen because I prefer blue pens, and you're going to write out your will. I, Jesse Campbell, is writing this as my will. I leave everything to my spouse. And in the event that he doesn't survive me, I leave everything to my cousin, and I'm going to sign it, Jesse, today's date, October 2nd, 2025. And that would be a valid will. It may not be a good will, but it's a valid will, right? It has everything that you need in it. It has my name. It says who I want to serve has, I didn't say that. I leave everything to my spouse, and I want my spouse to serve as my executor. So name's my executor, name's my beneficiary, name's my alternate, and then I sign and dated it. It doesn't cover everything that could potentially be there, but it's valid, and we will be able to go to court with our handwritten will. Okay. And that's it, by the way. You don't need witnesses or anything along that lines. That is a valid will, all in one or your own handwriting, signed and dated by you. You cannot designate someone to do this. You cannot be on your bedside and say, "Hey, cousin Jane, I need you to come over here and listen to me as I tell you what I want my will to say. And then she takes it out and writes it in her own handwriting. That's not a valid will in the state of Texas. You cannot designate someone else to write in their handwriting your will. So what happens when you pass away with a holographic or handwritten will? You're going to go to court. Your Honor, I present to you a holographic will. There's no witnesses on this, and so what we're going to have is two um, people to come and testify that they know the person's handwriting. They are disinterested. They don't, they're not going to get anything out of the will, or the estate doesn't owe them any money. They're just people who happen to know the handwriting of the person who passed away. So you need two people to come to court and testify to that. Now, I'll tell you, I don't know very many people who know my handwriting that's not related to me and would be interested in what happens to my property after I pass away. So that can be difficult. That can be difficult to find somebody who knows the handwriting of the person. But that's the process that will happen when you go to court. Which means you might want to consider getting some witnesses. So you can do a handwritten will, and you're going to do the same thing, sign and date it, and then you're going to have two witnesses over the age of 14. They can be teenagers here in Texas. Again, disinterested. They're not going to inherit anything on the property or things on that line. They're going to have seen you write and sign and date your will. They're going to also sign and date their will. The will has witnesses, and so now you have a witnessed handwritten will. And now what happens when you go to court is that, Your Honor, I give you a handwritten will that's been witnessed, and now we will need to bring one person, one of those witnesses, to the court to testify, not to the handwriting, but to the will. They will be testifying, yes, Your Honor, I was there. They told me it was their will. They signed it in front of me. I was there, and yes, we're going to be able to do that. And so then the judge will say, okay, now we're going to admit the will into court. The second type of will is an attested will. Again, just legal language for a will that is 100% typed and that is signed and dated. So in this case, you're going to pull out your handy dandy computer or your typewriter. You're going to clickety clack. You're going to write it out, and then you're going to print it up, right? In this case, yes, by all means, Jane can come next to your bedside with her computer. She can type it out and she can print it. You're going to read it, right? You're not going to just trust that Jane wrote exactly what you said. You're going to read it and make sure you know what it says. If you've done that, but now you have a typed will. What is required for a typed will is two witnesses. You must have two witnesses. So that's the difference between a handwritten will and a typed will. In a handwritten will, you can do it without a witness. No big deal. It does make the probate process harder if there's no witnesses, but doesn't mean it makes it any less valid. But for a typed will, you must have two witnesses who are over the age of 14 and disinterested. And when you're looking at them, they're going to see you sign the will and date it, and then they're going to sign the will and date it. And just like the handwritten will, when there's witnesses, the same thing. Your Honor, I bring to you a typed will that's been witnessed. I have one witness who was there that day testifying that, yes, Your Honor, I was there. I saw them. He told me that it was their will, and I watched them sign it. And there we go. Judge will say, okay, we're going to admit the will. Now, I hope everyone's asking the same question I would ask. What happens if you can't find a witness? The best thing you can do is to prevent the problem before it starts, which is, if you are able to do so, you're going to execute your will with what is known as a self-proving affidavit. A self-proving affidavit is one that's signed by the testator and the witnesses and a notary at the same time of executing the will. And so you're going to come, you have your typed will or your handwritten will, you're going to sign and date it, your witnesses are going to sign and date it, and then your notary is sitting there, and now you're also going to sign and date an affidavit. Your witnesses are going to sign and date that affidavit, notary is going to stamp it and do their signatures. And so what happens then, at the time that you're going to go to court? Your Honor, I present to you a self-proved will. Doesn't matter if it's handwritten or typed. I present to you a self-proved will. Judge is going to look at it, and there's going to be some testimony, and it's going to be like, all right, no witnesses required. So when you are able to do so, it's always highly recommended that you do a self-proving affidavit with your will. If you get an attorney to draft your documents, they will automatically do that. And when you come back next month to hear about the forms that we'll talk about then, it will also be included in that. So I just got asked about witnesses coming to court. Is it, it's testimony. They're testifying subject to perjury, right? They'll do an oath, but yes, it is a verbal testimony. In some instances, you can potentially do it in a written state, but it's going to kind of be dependent on the situation. And that would be a question for the attorney on what happens if the witness is unable to attend the hearing. All right. So types of wills, fill in the blank. Ooh, I talked a little bit about some forms next month, right? Generally, this is really important to know. There are no fill in the blank wills in the state of Texas. The law is written very clearly. It has to be 100% in your own handwriting or 100% 100% typed. That's what the law says. A few years ago, Austin and his legislators instructed the Texas Supreme Court to draft some templates, some pro se wills for the community, for individuals in Texas. They are fill in the blank when you look at them. Are those valid? Yes. The understanding is it's yes, but I'm going to tell you, as a lawyer, if you are going to use the form, and I'll tell you again this next month, please, it is my strong preference that you type it into the computer and print out that fill in the blank form so that it is 100% typed. So while the form says it can be fill in the blank with the pen and typed, it can be mixed. As a lawyer, and most every lawyer I talk to or see when they're talking about estate planning, so highly recommend that you do this with typing it into the form on the computer and then printing it, because the way that the law is written, you don't want to test anything, right? So, all right, now we're going to talk about transfer on death documents. I already talked about how you can do your bank accounts to make it so that they don't have to go through the probate process. Remember, so you're going to do a payable on death account or potentially joint owner, but at minimum, you're going to do a payable on death account. There's our other two major properties that we tend to own is our house and our cars. And those are considered probate properties, right? So if nothing else is done, it's going to pass according to the will. And so now we have but now we have in Texas what are called transfer on death documents. They've been in place for about 10 years, so it's really great. And so with transfer on death documents, it's a way to transfer property without going through the probate process. For real property, land and house, you can do what is called a transfer on death deed. It is a deed, just like a warranty, a quitclaim deed. It's a deed. So you're going to draft a deed that says, upon my passing, this is where my property is going to, who it's going to go to. You're going to name alternates. You're going to fill out the form. We'll talk about that next month as well, right? You're going to do all that. You are required to file it. You must file it in the county records where the property is located for it to be valid. So then you're going to file it. And then that's it. It automatically transfers. The only thing that has to happen is that a certification of death has to be filed. And then you have clear title of the property without going through the probate process. Really super important to remember this. A transfer on death deed and document takes priority over a will. So if you decide that you're going to give your house to Sally and you do that in a transfer on death deed, and you file that. Then you change your mind. You're like, no, I really want Bob to get the property. And you put that into the will after you filed the transfer on death deed. Guess who's getting the house? Sally is. Bob gets nothing because the transfer on death deed takes priority over the will. Same thing. Timing does not matter. You write a will giving the property to Bob and you change your mind and you give the property to Sally. Sally's in a transfer on death deed. Sally gets the property. Transfer on death deed takes priority. So if you change your mind and you've done a transfer on death deed, you either need to file a new transfer on death deed. It's automatically takes over, supersedes the old one, or you need to file a revocation in order for Bob in the will to get the property. So really important to remember that. It's a really good tool to help transfer property. And when in the right situations, but you want to be sure that if you change your mind that you actually do a revocation and do it properly to ensure that you want to get the property does get it. For a vehicle, a car, RV, you're going to do a beneficiary designation of a motor vehicle. That gets filed with the tax assessor collector's office, where you do your titles, where your car titles are. You're going to complete a form and do an application for a new title. There's a fee with that. Depends on the county, typically between $80 or so. And then after you complete that, then what you will get in return is a beneficiary designation car title Then all that needs to happen is the beneficiary will have that, get a copy of the death certificate when they want to sell the property, sell the car or anything, and then that's the valid documentation. Again, that one also has to be filed for it to be effective. Really good tool. Now, I kind of get questions on like, should I do it for my car? It depends, right? I say for sure if you have an RV, do it. Most people keep their RVs for decades, right? It's usually a home replacement for some people. And so you want to go ahead and do that for your RVs. But, I'm in my 40s and I just bought a new car. I don't think that's going to be my last car. So I'm probably not going to do it for the car that I just bought a couple of years ago because I'm probably going to get another car at some point in time in the next 20 years, right? And so I probably am not going to do that. And you're like, well, Jesse, you kind of like, what happens? You told me I need to go to probate for a car. Well, the good news is the reason why I get a little bit more like, it's okay if you don't do it for a car, because assuming that the beneficiary is like your spouse or your children, there is a form that you can file the with DMV, Department of Motor Vehicles, that will show like who the property should go to. It's pretty easy. It's pretty simple to be able to do that. But that being said, individual plan, remember, individual plan, you got to think about that, because if the intestacy laws is not where your car is going to go, then you're going to want to be sure it's in the will, and then it will go through the probate process, but doesn't mean that the probate process is going to be more difficult or anything like that. So just kind of think about like what you want, right? So in terms of doing that. Here's the good news. I forgot. There's a third one. As of September 1st, and I did not update my PowerPoint. Apologies for that. As of September 1st, it is effective now. There is a transfer on death document process for mobile homes. So for mobile homes, you now would file an updated statement of ownership, making a beneficiary designation, and you would file that, and it would be able, and then it would you get the same thing as with the car. Like you will get the updated ownership documentation, and then with the death certificate, that will be who owns the property. So that's been a change. It was mobile homes kind of fell into this gray area, when it came to the transfer on death documents, because it's like, oh, is it real property? Is it personal property? Because a mobile home can be either. And so it's been made very clear that for a mobile home, it would be it would be filing a new statement of ownership with a beneficiary designation on there as well. So good news for mobile home owners out there. For any of this, you still own the property. Just because there's a document that says someone else is going to get it upon your passing doesn't mean that they have any rights to it. They don't. You can do whatever you want. You can sell your car. You can sell your house. You can renovate it. You can put a reverse mortgage on it if you wish. You can get a home equity loan on it. It's still your house. You still got to maintain it. You still got to pay the property taxes and things on that line. And then, Bob, I guess Sally's getting the house, right? Sally can't go down to the bank and say, hey, look, I'm going to inherit this house. Can I get a loan with using this house as collateral? No, she doesn't own the house. You do. So just be aware of that there's no commitment. You can do whatever you want with your property still afterwards. Something else to kind of consider, though, is that always be careful about this. While it is an excellent tool and will work for many, many people, and I think if it works for you, then you should consider doing it. But it's not the right one for everybody. So what are some of the situations where you may not want to use a transfer on death document, and you may want to make sure that the things are in the will? Right away, remember what I said. Even with these transfer on death documents, you're still going to have a will, right? We're still going to have a will. That the instructions. If you have instructions, you cannot put in a transfer on death deed. So what are some types of instructions that we might have? Well, I've been living in this house, and the roof kind of got messed up, right? And and Sally fixed my roof. She gave me $10,000 out of her savings account, replaced my roof. I know y'all are planning on selling the house. I want the first $10,000 of the proceeds of the house to go to Sally, because she deserves to get her money back, and then the rest of it be split between Sally and Bob. That's an instruction. You cannot put that in a transfer on death deed. You need to put that into a will. Other types of instructions will include what are called life estates. I want Sally to be able to live in the house. She's been taking care of me. She moved in to take care of me, and her kids, are currently going to this great school, and they don't want to move out. I want her to be able to stay here until her kids graduate from high school. And then at that point in time, if they want to sell the house, then they can sell it. That's a life estate. That's giving her permission to stay in the property, but the ownership is going to be between Sally and Bob, right? And so that should also probably go into a will. You cannot put that in there. I also highly say proceed with caution when you're going to have more than one person inheriting property. One of the things that we do when we're writing estate planning is to avoid conflicts. So you have three people inheriting the property under a transfer on death deed. One person wants to stay in the house and keep it, but the other two people want to sell it. What happens? That type of situation is so much easier to handle when there's a will and a probate that's been open because it allows for family settlements, family conversations. Whereas when it's in a Todd, a suit will have to be filed potentially. There may be a lawsuit that has to fight it. And it can become complicated, it can be difficult, it can destroy families. Property conflicts can make it so that people don't talk to each other again. And so things like that, be really cautious about that. Doesn't mean that you can't do it. You know your family better than I do. Like, I'm not here to tell you that, yes, everyone's going to fight. But if there is a possibility that there's going to be conflict around that, it's much better to go ahead and put it into a will and have it be handled under the probate system where there's a lot more flexibility to be able to negotiate, to kind of figure out how can we, one person buys out the other person in order to kind of create the better settlement as opposed to kind of creating a situation where the only option is to sue as opposed to work on a mediation. Okay. All right. So some quick questions about Todd. Yes, Todds are revocable. You can file a revocation. It's not revocable by will. You have to file a revocation or file a new transfer on death deed to take over the one that was filed before. So that was the first question about Todd. And there's another question of, does that include division of property by percentages? Yes. So if it's community property and you own 50% of the property with your spouse, your transfer on death document is only your 50% of the property. So if you have Sally and Bob from a previous marriage and you have or even this marriage, right? Like if Sally and Bob are named as your beneficiaries under the Todd and it's not set up, and depending on how the Todd is written, it does depend on how the Todd is written, but let's assume standard language, right? Then Bob and Sally will inherit 25% because they will be getting, so you're like, I want my percentage to be 50-50 with Bob and Sally. Well, he only has 50%, right? So Bob and Sally only get 25% each because the remaining 50% is owned by Barbara under the community property. They both own it together, so Barbara still has 50%. But you can do a Todd for percentage. You can do a Todd for mineral rights. For those of you who are fortunate enough to have some oil mineral rights, you can do a Todd for mineral rights. It's in the county where that well is located. So yeah, any kind of percentage as well has real property, but something in a real property interest can be done with a transfer on death deed.
No, I meant specifically if someone wanted property to be divided that they want to allocate to someone by a percentage. Like I want
Oh,
10% of my property to go to this person. I want 25% to go to this person, like that.
yes, you can do that in a transfer on death deed for sure. Again, it's kind of that buyer beware kind of thing where I like you should really think about that before you do it because it can cause some problems. But yes, you can do that, but you cannot do that in the standard forms. Typically transfer on death deed documents it tends to be equal allocations. If there's two people, Sally and Bob, they're going to get 50% each. That's how the document is written typically. But it is possible to do percentages. I highly recommend against it though. That's things like that should probably be better handled in a will. But you need to be kind of very cautious on that.
So if that's what they want, talk to an attorney first.
Yeah, just to be sure it's okay. Yes, mobile home is the same as a manufactured home. My apologies for not using both terms. All right. Trusts. Trusts are outside the scope of today, but we do need to talk about it because it can be an advanced planning option. So what is a trust? A trust is an arrangement where a person or entity called a trustee holds a legal title to property for another person called beneficiary. That's what a trust is. In simple terms, that's what it is. But there are many different types of trusts: living, revocable, irrevocable. They can have different purposes. They can have a special needs trust. They can have meet the needs and medical expenses. There's so many different things that a trust can exist for. This is what I always tell people. You should talk to an attorney about whether or not you need a trust. It doesn't mean that you don't need a trust, but I always say, what is the purpose? What is the goal of the trust? Sometimes people come to me and they're like, well, I watch a TikTok for the man on the street. Nia calls it the street committee, which I love. I should take that. But like, right, you got somebody, you've watched the Today Show or CNBC or something. Someone has told you, if I was to write my will, I would rip up my, if I was going to do my estate planning, I would rip up my will and I would put everything into a trust because you want to avoid the probate process altogether. No, not in Texas. Texas actually has one of the easiest probate process in the nation. Estate planning and probate laws are governed by the state, not the federal level, not by any other state. There are states where the probate process is very complicated and difficult, and their estate planning is trust planning. That's what they do to minimize the problems in probate. In Texas, our estate planning and to minimize problems in probate is the will, a well drafted, properly executed will. Because when you have a well drafted, properly executed will, the only time you go to court is when you bring the will to the judge. Your Honor, here's my will. It's self proving. There's no witnesses. It's valid. Okay. Judge signs, executor is sworn in. There's one other document that has to get filed, which is an inventory. And then the executor does their job. They sell the property, they repair things, they write the deed conveying the property to Bob and Sally. Now they're doing all of that work. Here's the secret. All of that work that they're doing in the probate process and doing all that still has to be done for a trust. The question is whether or not you're doing it before or after. Are you funding the trust while a person is living? Or, and this one I've seen, they have a will that says they want everything to go into a trust to have the trust be right. But the instructions to the trust is to disperse it to the beneficiaries. So it's so what's the goal? Like what is the goal and why you need a trust? It should be what's governing it. And when someone says I want to avoid the probate process, that might not actually be a good enough reason because it can actually be more expensive to create a trust than it would be to write a will and have it go through the probate process, depending on how that trust is written and what needs to be done. Now, there are trusts. There are sometimes you do need a trust. Minors, if property is being inherited by minors, I already mentioned at the beginning what happens if a person is inheriting property and they're living with a disability and an inheritance may impact their benefits, right? So there are needs for trusts. Sometimes there is a thought process around a long-term care planning. We'll talk about that in a little bit. So there may need to be but those conversations need to be made with an attorney. And because you don't want to have unintended consequences doing a trust and it doesn't actually accomplish what you hope it would accomplish, which is to save money and to make things more quickly. And it actually can make it much more complicated afterwards or at the beginning part of things. So discuss that with an attorney. Okay. Some bad news for everybody. I do get this question quite frequently. It's like, what happens with debt? So debt survives. There is a misconception that debt goes away when a person passes. That's not true. The estate is responsible for the payments of any remaining debt that is owed at the time of passing. That obviously would include funeral arrangements, hospital bills, all of those types of things. The estate is still responsible for that. Credit card bills that had debt balances. Some creditors will write it off. If the estate's insolvent and there's no money in the estate to pay off the debt, some creditors will write it off. They'll do a cancellation of debt. That doesn't mean it's done, by the way, right? Because at one point in time, you're going to end up getting a 1099-C for cancellation of debt. And then the estate is going to owe income tax for the cancellation of debt income. So, so be aware that that doesn't mean that the debt goes away. But sometimes when an estate is insolvent, there will be a cancellation of debt. They don't file a 1099-C and then the debt goes away. And so some people, some creditors do that, some will not. It really just kind of depends on the estate. There's a lot of times when a person passes away, before the probate even started, a creditor will file their claim in probate court to make sure that it's protected. So debt does survive, and it is something to consider. If you're a person who's carrying some debt, like how does that impact potentially the payment of it? If it's insolvent, it's insolvent, right? Like if there's nothing to pay, there's nothing to pay. The heirs don't have to pay that credit card. However, titled property for which the property is collateral is inherited subject to that debt. Unfortunately for us, there's no mortgage company out there being like, oh, yes, you get to keep the house and not pay the remaining 15 years of that mortgage that is still remaining, right? It would be wonderful if that was true. Unfortunately, it is not. So if there's a mortgage on the property for a house, there's a car loan on the car, if you don't pay that, they're going to come and take it, right? You're going to get foreclosed or the car's going to get repossessed. So someone has to pay for that, right? And so we have to be aware of that. There's different things you can do to prepare for that. One, let them know, Bob, you're getting this house. I know you love it, but just let you know right now, I got 17 years to pay on it, right? Before that loan is paid off. And so if I pass before that, there's going to be a mortgage on it. So you need to be aware of that. Bob might be like, that's fine. I'll go ahead and I'll finance it. I'll figure it out. Don't worry. I got it, right? Um, but Bob may be like, no, I really don't think I would be able to keep it. I would want to sell it, right? Okay. Then you might want to consider doing a transfer on death deed to Bob so that Bob can own the property quickly and then he can sell it as soon as possible. So that way, then he can pay off the mortgage, right? So that's an option, or you can put it in the will. Or maybe you have a life insurance policy that will pay off the mortgage. And then you give the life insurance policy to Bob, being like, hey, Bob, I'm going to give you that $50,000. I'm giving it to you for the purposes of hoping that you can pay off the mortgage. That's all that's going to be left on the mortgage, and you can get the house free and clear. Different things, different scenarios. Remember, individual plan. You got to think about what's going on, who's inheriting a property, what type of property, right? So there's different options that might come into play depending on your situation to kind of deal with that, right? So same thing with a car. The thing that is most important to remember about this is reverse mortgages. Most mortgage companies, most car loans, as long as the mortgage is getting paid and the car loan's getting paid, they'll work with the estate, right? They're like, okay, well, the deed hasn't been transferred yet. It's going to take about 6 months or 8 months for the estate to go through its process. As long as I'm getting paid, as long as the estate's paying the mortgage, car loan, we're good. We can work on that. Reverse mortgages are not the same. Reverse mortgages are due 6 months after the date of death. And so that's not a long time. Remember what I said earlier, the average length of time when a probate is started is 4 months. So 2 months is not a lot of time if they're planning on selling the house in order to pay off that reverse mortgage. So you may want to be thinking about either let them know a reverse mortgage happens so that way they get on the front end, right? They get on the front end to in the probate process, get it filed so that way they get the home transferred and financing done and get the house and get that reverse mortgage paid off, or do a transfer on death deed, has an option because they're planning on selling it and things like that. What you don't want to happen is that they're under a gun and then they're going to get the reverse mortgage deadline is looming and then they're not able to sell the property. They're planning on sell the property at its fuller value, or not enough time to get financing to be able to transfer in order to pay off that reverse mortgage and keep the home. So be aware if you have a reverse mortgage, that is going to be something that your executor needs to know, your beneficiary of the home needs to know, so that way they can start making those plans as quickly as possible, because 6 months is not a lot of time and to be able to do this. Oh, so I mentioned the cancellation of debt income when and then you have to file the income tax. What you do is that the estate files a document with the IRS claiming the insolvency, and it's typically an offering compromise is typically the document that gets filed, but there's I think another document, and then the income tax is discharged for an insolvent estate. And so the question is, what if an estate is insolvent or have no funds? How does the estate still pay the income tax of the discharge debt? When that comes in, there's income tax on that. Then there is a document filed with the IRS showing that the estate's insolvent, and then the income tax is discharged. All right. Last document when it comes to preparing for death, and then after this, it goes really fast. Disposition of remains. This is a legal document to put a person in charge of funeral arrangements. That's really what it is. You will be surprised how many people will fight over funeral arrangements and what needs to happen over that. And so this way, you're naming the person who's going to be responsible and the final decision maker as it relates to disposition of remains. In the same document, you can include instructions, including whether or not there's pre-arrangements have already been made, what you want for funeral arrangements, if there's burial plots already. So those information can be put into that. But really the purpose is to minimize conflict and say, Bob's in charge of the funeral. Sorry, Sally. Bob's in charge, right? So, and of course, tell Sally. It's not because you don't think we can do it. We just want Bob to do it. Right. Documents go much quicker after this, and you're going to see why, right? But now we're going to talk about incapacity. So basically, when we're talking about preparing for death, there's two things you got to do. A will and transfer on death documents is really what it is. And disposition of remains, right? But when we're talking about planning. So we got a lot more documents as it relates to incapacity because there's different timing of incapacity. So the first document is an in-between. I call this an in-between document. A supported decision-making agreement. This is not a power of attorney. This is not a person who's being named to make decisions on behalf of someone. So this is a document that is signed by an adult who needs support. That's what it is, right? Support decision making. It's a person who is very useful for children as they age up into adulthood who may have some diminished capacity where they're not able where they need someone to explain financial documents to them, right? It's also very useful for people as they're aging, as we get older. Some of us will experience a diminishing capacity. Still means we know what's going on, we can still make decisions for ourselves, but we're less likely to identify scams, say, right? That's true. Unfortunately, as some of us age, our ability to spot scams is really difficult. And plus, also, my goodness, they're getting so good now. Some of these scams. Um, and so what this document does is that it informs people that the adult, the person who signed the document, wants the person they've named as their supporter to be available to them to help them make those decisions. And that's what it is. The supporter does own a fiduciary duty. What does that mean? That they are making decisions in the best interest of the adult. That they're doing everything they're doing is in that adult's best interest. No, I'm sorry, they don't make decisions, but the advice that's being given is keeping that other person in mind and what they want to be able to do. We're not stepping in and making decisions for them. We're coming in and being like, have you thought about this? Have you thought about that? Here's some research. Let me show you what it is. Do you understand this document that you're signing? Right? And you will do that. It is a less restrictive alternative to a guardianship and something that the court does require you to consider before they will order a guardianship for a person with who's incapacitated. Right? Now we're going to talk about actual incapacity, right? So statutory durable power of attorney. Going forward, almost every document that we talk to is going to have two sides. The first side is financial and legal matters. The second side is medical. After this, everything has two documents as it relates to financial legal matters and one for medical. Statutory durable power of attorney is the one for financial and legal decisions. So when a person is incapacitated and there's a statutory durable power of attorney, that durable power of attorney will allow the agent, the attorney, to go in and open up a bank account, to go in and call the credit card company and be like, hey, I need you to close this account, right, if that's needed, right? So they'll be able to come in and make those decisions. This is the only document that has a timing to it. There's two things you can do. You can make it effective immediately, which is the default. When you look at the template, it's a default, is to have it effective immediately. You don't have to have it effective immediately, but you can. Why is it good to have it effective immediately? It's just up to you. It's whether or not you think you want it. The other one is springing, which is at the time of incapacity. That's determined by a doctor. So a doctor has to do an examination, then make a medical decision that the person does not have capacity to make legal and financial decisions. There's usually a letter that's associated with that. And now in combination, now the person has the ability to go make financial decisions. They will do both the power of attorney with the doctor's letter, and then they're able to make the decisions and do what they need to do. There's no right or wrong here. Some people are like, I want to be able to do my own thing until it's ready, till I can't, and so I want it springing. Some people will do it immediately because it removes the barrier of the doctor having to make an appointment. Like, what happens if there's something happening really quickly and something needs to get done? I don't want to have to worry about this barrier of having to get to a doctor. The other time that you may want to consider having to do it immediate, if you already have a person, right? So if someone's already helping you and doing some stuff and they're already doing this thing and you've had to give permission to one bank and then another permission to a credit card and like right? Like this is an effective tool if someone's already helping you. For example, I am my mother's power of attorney on her durable power of attorney. It's effective immediately, and we do it for one reason and one reason only. My mom does not like to talk on the phone about her banking. So if there's a situation that requires us to call the bank, I have a power of attorney that lets me do that. It's, and that's it. That's the reason why we have it effective in my family. But be careful, right? Like, this is a dangerous document because someone can go and open up a bank account, open up credit cards, go buy a house in your name, sell your house, right? So this is a darn powerful document. Be really, really mindful that the person that you're going to be putting in charge of that is not going to do something bad, right? It's very hard, right? Like, once you lose capacity, you can't undo it, right? You don't have capacity, and there's nothing you can see to do that. And obviously, sometimes you might not even catch it, even if it's effective immediately, and you do have capacity, right? So be really cognizant of who you're putting in charge of that. And unfortunately, I have seen people use this document to cause harm for the person who trusted them. So we got to kind of be mindful of that kind of stuff when we're picking who should serve in that role. Um, let's see, just making sure about this question. Okay. I'm gonna have to come back to this other question.
I'll remember to go over that one at the end.
Okay. All right.
Okay.
So does a durable power of attorney expire? No. So why it is a durable power of attorney is that it survives incapacity. You can have other types of power of attorneys, but this is the durable one that's about planning for incapacity. It doesn't expire. But you can revoke it, right? Does it have to be filed? It does not have to be filed, and I'm assuming we're talking about some kind of county records, but it can be. It can be filed, but it doesn't have to be. If there's a revocation, highly recommended that that is filed into personal records in the county. Um, I don't think you have to show an ID of the loved one. If it's asking about like when you go with the power of attorney of the person, no, because the signature and it's signed and notarized by the person. There are instructions that are attached to the power of attorney about what you have to include when you're doing work. It's a two-page document with all the instructions of what the requirements are when a person is acting under the power of attorney. All right. So now we have the other side, medical power of attorney. Medical power of attorney is names a person make medical decisions when a person is unable to do so. It's effective only at the time of incapacity. Obviously, as long as you have the ability to make your own medical decisions, the doctor's going to listen to you because you're able to make those decisions. So it's only effective after a doctor does an examination and determines that the person is no longer able to make medical decisions for themselves, and then the power of attorney goes into effect. And the power of attorney will also no longer be effective when the person has their capacity returned to them. So what would be an example of that would be a person who was in a car accident and they're unconscious, and someone has to make a decision about the treatment, and then the treatment is handled, and then the person wakes up and they're fine. All right, now that medical power of attorney is no longer effective until that person becomes incapacitated again, right? Like you don't have to redo a new one, right? So easy peasy. The thing about the two documents, statutory durable power of attorney, medical power of attorney, the reason why it's easy and I don't need to talk about anything else beyond this, they are statutory. What does that mean? Folks in Austin have already written it for us. They have told us what the form has to say and what it needs to include. And all it is that when you see the template, you just have to complete it. These don't have the same rules as it relates to handwritten versus typed. You can take a template, you can print it out, and you can write. You can write on it, and it will have the effect that it needs to have to be able to do that. Right? All right, key takeaways from this one. Everyone needs to also have a statutory durable power of attorney and a medical power of attorney. As soon as you are 18 and you want someone to make those decisions, you need to go ahead and have these in effect. Unfortunately, illnesses and accidents happen at any age, and we want to be sure that these documents are in effect. This is what gives you those last three things: the will, access to a bank account, statutory durable power of attorney, and medical power of attorney. Those four things, gives you the minimum protection that you need in your advanced planning. If you hear nothing else when you walk away, Remember, everyone needs a will. Make sure someone has access to your bank account and have a statutory durable power of attorney and a medical power of attorney. That will be the minimum that you need to be sure you are protected. Doesn't mean that's everything, but that's the minimum. Okay. And you can get by with a lot of this, right? You can power of attorneys can get by for a long time sometimes before a guardianship is needed. So some of this will really minimize a lot of problems for family members. Right. So now we're going to talk about some not optional, but good to have. You should have them. But if you're writing your own documents and you're like, it's too much, Jesse, then you can, then get just those four. Um, but designation of a guardian in the event of later incapacity. So the power of attorneys really are intended to be temporary. They're not really meant to be forever. Right? So the at some point in time, if a person is permanently incapacitated, they're never going to be able to, their ability to take care of themselves, make decisions for themselves, are not going to return. At some point in time, someone, a bank, a doctor, somewhere, is going to say, I cannot do anything further until a guardianship is established. And if you're just getting by on your power of attorney, um, it might be sooner, like it can happen a lot sooner, right? But somewhere, someone's going to say, we need a guardianship in place. A designation of a guardian names the preferred person in the event of a permanent incapacity, and a legal guardianship is necessary. This is a court procedure. As I mentioned in the beginning, there's an application filed with the court, and then the court will decide if a guardianship is needed first. They will do their examination with ad litem's and doctors and whatnot. And then they will name the guardian. Why is it preferred? Is because they still have to qualify, and a judge can decide if a person is not qualified. And it's the only time, right? And so that will be something that they will look into account. If there's possibility that the person you name, so when you're drafting these documents and you are working with an attorney, you may want to ask, it's like, well, the person has a criminal history, like they served in some time, are they going to be allowed to, serve as the guardian? Oh, a conviction is not enough, right? There's other things that, just having a conviction is not enough to make you disqualified. It depends on other factors. And so you may want to talk to an attorney to make sure that the person you're picking doesn't have something in them that would, in their history, that would disqualify them from serving. I mean, and that's just an example. You can also be disqualified from serving if you have bad financial management, like the person has demonstrated, um, bad financial management, or gambling, addiction or something like that. Like there's other reasons that a person can be disqualified from serving. Um, so just keep that in mind when you're naming that. You can also name an alternate. But just as important for some people, this is just as important and sometimes more important. Um, the judge, if you can name who you do not want to serve in that, you want to disqualify someone. So you're like, all right, these are my choices, Bob and Sally, they're going to serve. But I have a sibling, who lives in California, Jimbo, right? Whatever, right? Like, we haven't talked in 30 years. We do not get along. There was a big family fight. He is not my sibling in my eyes. We're disconnected. Well, then all of a sudden, for some reason, Bob and Sally are not able to serve as the guardian. And now the court has to go look at the next person. They're going to go look for the next of kin. And the person is Jim Bob, out in California, that you haven't spoken to in 30 years, and you've disqualified him. In that case, the court will not appoint Jim Bob, even if that is the next person in the list of the next of kin that would be the one they would look at. So for some people, this is really important to have. Just like with the power of attorneys, there's two. For guardian of the person, this is a person making a decision to the care and health of the ward, and a guardian of the estate, property, financial, and legal matters of that. They can be the same person. They can also be different people. You have them as different people, just be sure to get along, because while it may seem like they're two distinctive things, sometimes there's an overlap, right? If the guardian of the person wants to put their ward in a certain residential facility because of, for whatever reason they think it's the best one, and then the person who's the guardian of the estate is like, nah, that's too expensive, I want them to go to this facility, there can be a fight, right, as it relates to controlling the funds to pay for the care of the person. So again, if you're going to have two different people, just be sure that there are people that will not be in conflict, and then a court coming in. Next up is a HIPAA. HIPAA gets lots of media coverage, and it's always interesting because sometimes like I don't think people understand HIPAA very much. So HIPAA is the Health Insurance Portability and Accountability Act. What this means is that your medical information is private and protected, and the folks who are subject to HIPAA cannot share that information with anyone without the express permission of the persons whose record it belongs to. A HIPAA release gives that express permission to share that information with the named individuals. Um, so who's subject to HIPAA? Doctors, medical facilities, lawyers are subject to HIPAA. So if we have obtained medical information in the course of our representation, or in the case of the medical side, the treatment of that individual, we cannot share that without the permission. Now, if you told your neighbor about, your, you know, medical condition, your neighbor can go to their neighbor and spill the tea, so as they say, right? That's not protected. They're not subject to HIPAA, right? It's only certain people. So you want to be sure that you have a HIPAA release at minimum for your medical power of attorney and your designated guardian of the person. So that way they are able to obtain medical information so that they can make medical decisions going forward. Why do you need a generic? This is what it is. It's a broad, applies to everybody HIPAA release. You're like, I filled these out with my doctor every year. The ones you fill out with your doctor or a hospital when you get checked into at a hospital only applies to that provider, to that facility. And so so what happens if you are, you get transferred to a different doctor and now they need medical, now we need to get HIPAA release to be able to get that information shared. So you just want the general one, so that way you have one across the board, because you can't take the HIPAA release that you signed at your primary care doctor and take it over to the hospital and then say, okay, this applies here. The hospital won't honor that. So, right. Advanced directive to physicians. This is commonly known as a living will. This is into life decision making, or not into life decision making. This is a heavy document, right? We're talking about what we would like to do in certain situations. The situations are terminal condition. This is defined as a person has been diagnosed with a condition that even with life-sustaining treatment, they are expected to pass within 6 months. An example diagnosis would be an aggressive stage 4 cancer, is a type of diagnosis. An irreversible condition is a condition in which it is not terminable, but can be in the event if life-sustaining treatment isn't provided. So the condition in and of itself is not terminal, and you can live in that condition, but you need to make some type of life-sustaining intervention. So an example would be a coma. Some people do come out of comas, but but there is a possibility that a person may not come out of a coma. So that would be considered an irreversible condition. For each of these, the options are stop treatment, except to keep me comfortable, let me pass peacefully. The other option is to use all available life-sustaining treatment. Now, within that, you can add some additional instructions, right? Yes, I would like all life-sustaining treatment, but I don't want artificial nutrition. I don't want to ever be put on a respirator. In the event that I would be put on a respirator, I would like to be able to pass peacefully. There is an option. It's typically not in most templates. If you look at templates on here and you will not see it, which is the decision by the medical power of attorney after conferring with a physician. Here's a hint. Most of the time, the doctors will talk to the medical power of attorney. Most doctors will not take this document and just make a decision on their own. They will typically talk, that's what they almost always will talk to the medical power of attorney before any kind of decision is made, before they do anything, assuming that there is time not to wait to do anything. And in that case, you can put that into the document as well. So you definitely should be talking to your medical power of attorney about what you would want, some scenarios and what your expectations would be in this. This is heavy. The likelihood is that the person that you've asked to serve as your medical power of attorney to be part of this decision-making process is someone who loves you very much and are being asked to make a very difficult decision about someone that they love. So I don't know your family. I don't know your dynamics. I don't know who you would be selecting, but have a conversation with them. For some people, you may need to consider, if you're a person of faith, maybe going to your faith organization and talking to counseling there, or even a private counselor, to be able to kind of have these conversations. Offer forgiveness if that's something that is needed in your dynamic. This is the counseling side of me. This is hard. This is a hard thing, and no one wants to think about it for the most part. And so, but it is conversations that can help ease things if this document is ever needed. It's also important to know that this document does not replace a hospice plan. So just like the medical power of attorney, when you have capacity to make decisions for yourself, your plans are always going to take precedence. So if you have come in and made a hospice plan, the hospice plan will govern, not the advance directive. Our last document, we're almost there. It's long, I know, heavy 2 hours. We're almost there. Is a declaration for mental health treatment. Not everybody needs this, but it's a really useful document for those who do. So it's also known as a psychiatric advance directive, PAD for short. This document is for individuals who are at risk or have a history of psychiatric hospitalizations. An example diagnosis would be schizophrenia. And so they have a risk of being hospitalized. This document allows the person in advance to make decisions on the type of psychoactive medication they are given when they are not able to make their own medical decisions, convulsive therapy, as well as emergency mental health treatment such as restraint or seclusion. Right? The person doesn't have capacity when they've been put into this hospital. They do not have capacity to make medical decisions for themselves. But once they regain their capacity, some of this activity can have a detrimental impact on them. And so this is a way for them to be able to say what is needed at this point in time. Psychiatric hospitalizations do require a court order, typically. But this document will go into effect at that point in time. The best care for the patient is what matters. But this is a really good document. If you or you know anyone who does have this as part of their history, it's really important. It's not as well known as a lot of these other documents, but they can get it, and so that way they have it as part of their medical record. Unlike the other documents where you should be looking at them at major life changes or property changes and things like that, this expires. This is the only document that actually expires. The Declaration of Mental Health Treatment is only valid for 3 years from the date of signature, so it needs to be re-executed every 3 years. All right. All right. Next up, long-term care planning. As I said at the very beginning, this is probably its own conversation topic because long-term care has a lot of different things around benefits and decision-making, things along that lines. Today, we're going to be focusing on what you need to be aware of for advanced planning purposes. Long-term care planning is when we're thinking about what our property means as it relates to the eligibility for benefits, specifically Medicaid. Medicare only covers a certain amount of long-term care residential treatment. Most people will run through their Medicare benefits. And we're talking about people who are on Medicare. Once the Medicare benefits run out, which is pretty quick, then we look at Medicaid and being eligible for assistance via Medicaid. If you end up using Medicaid for long-term care, it will be potentially subject to the Medicaid Estate Recovery Program, commonly referred to as MERP. This is where the government says, we provided for the care of this individual after they pass away, then we're going to come in and do a recovery. We are now going to take the property of the estate to pay for the expenses that the state covered. So that is what MERP is. Don't know about you, but many people would like their house and their property to remain with their beneficiaries, with their family, with their surviving spouse, and things like that. There's a lot of protections against MERP that has nothing to do with these documents. But if you believe there's a possibility based on family history or current diagnosis that you will end up in long-term care requiring Medicaid, there are things you need to be thinking about as it relates to doing that. For real property, there's 2 types of documents that you can do to protect your property, or in planning for long-term care more specifically. One is known as the Enhanced Life Estate. This is commonly known as a Lady Bird deed. This is a transferring of property during our lifetime with a retained life estate. It's very specific. This is something that is typically done to become eligible for benefits. as well as to protect against the MERP claim. But nowadays, it is more common when you're talking about just MERP. We're only worried about MERP and the recovery, that you can also do a transfer on death deed. And the transfer on death deed protects the property from the MERP claim as well. So both are options. Which one really depends on the situation. Do we need to put property into a ladybird because we need to become eligible? We have property that's going to prevent us from becoming eligible for Medicaid. That's when you're going to probably consider doing a ladybird. But if we're worried about the after part, the person has now passed, and we want to protect it for the beneficiaries, then a Todd is going to be the likely path forward. You should talk to an attorney about it. You should talk about what's going on with the property, what we're looking at, and why, and what the options may be that need to happen. Things are subject to clawback. What's clawback? Basically, it's that if you transfer something in the previous 5 years, the those who are making the claim can look at that as a transfer, and they can undo that transfer. If the reason why that transfer was done to become eligible or things like that, they can undo the transfer and then force the sale of that property. So this is really complicated. I can't do this in like 10 minutes, right? So, but just kind of keep that in mind. That, like, what are we thinking about? Do I need to become eligible, or am I just worried about protecting the inheritance? Then that can impact that. Now, becoming eligible for income, because if you have income, that impacts your eligibility under Medicaid. So this is going to be a situation where you have a married couple and there's multiple income sources coming into the house. Then you would do what is known as a qualified income trust, commonly called a Miller trust. This is for income only. It is an irreversible document. Once it's put into effect, you can't undo it. But this allows one person in the household to continue to work. That income goes into the Miller trust that preserves the eligibility for the one who isn't working, who needs the assistance that's gone on and who has gone on Medicaid. Again, all of this you should probably discuss with an attorney to make sure that the right documents are going to be in place. Some of these can have unintended consequences, and you don't want to do that, right? You don't want to put something into a Miller trust and then all of a sudden it impacts your way of working and how income needs to be coming in, or somebody else, right? So, and same thing with choices between a ladybird versus a Todd, right? You want to be sure that things are kind of being done the right way. So just kind of keep this in mind. Again, not everyone's going to need it, but the estimates right now is around 80% of the population will need some form of long-term care in their lifetime. So what's next? Um, it's just kind of administrative at this point in time. We're done. We're almost done, y'all. So you're going to create a list of accounts. And so you're going to list all your credit cards, your mortgage companies, life insurance, because what's the good in doing all this work if they don't know where to go find it, right? So you're going to put a list of accounts, contact account information if necessary. If you have things on the computer, you want to be sure that they can access to your digital assets. We actually had a very interesting situation. We were trying to figure out how to get into some cryptocurrency where the only way they could get access to the account was via the phone. We had to get a court order and things like that to get the phone open. So be sure that people can get access to your digital assets. By the way, that's just an example of the crypto. It includes like your Facebook account, your digital photos and things, right? People need to be get access to that. And where do you keep your documents? Safety deposit box. Word of warning on a safety deposit box. If you put your will and other documents in there, the only people who are allowed to open that box is another account holder and a key holder. So you cannot just be an account holder. You must also be a key holder. Otherwise, it may require a court order to open up the safety deposit box. And the only person who can walk in and take anything is the person whose name is the executor. The person who shows up is not the document. It's not the executor. The bank cannot give you that document. So if you're going to do that, be sure you make sure that the people can get to it. The other question I get is, must it be filed? No, you don't have to file your will or any other document in the county records. You can, not required. It is protected. They are private, right? And so just because a will has been filed doesn't mean that anybody can just go and find your will and see what you're planning on doing. It is protected, but it's also not required. You're not required to have your will filed with the county clerk. So what do you do? I say keep it in a safe place. Where are all your other important documents? Where's your social security card, your birth certificates? That's where I would put them. That's where, so, it can be a lockbox. If it's a lockbox and there's a combination, be sure the person knows the combination or they have a key, right? Or where to find the key, right? Be sure whoever needs to get to it needs to know where it is, right? So be sure that you tell them what's going on and how to get to it. And then have all the relevant conversations that I've mentioned throughout the day, right? Talk about the choices on being an agent, explain how you want your property to be dispersed, and how you would choose to make medical decisions. That's the thing you're going to do after that. And then, of course, make sure that the agents and the executors, whoever the representative is, know where the documents are, know how to get to them, and be able to get to them. So, just a final reminder on the key takeaways. When a person passes away, they must do something. So, when you talk to your executor, you say, honey, when it's time, I need you to take this stack of papers and go find a lawyer and talk to them about what we need to do next. There may or may not be something, but it's better to be sure that we don't have to do something rather than find out like years later that something had to be done and now we have a bigger problem to solve. Everyone needs a will. I don't care if you have a Todd. I don't care anything about it. Everyone needs a will. Be sure you have one. Be sure people have access to the bank account, and then everyone needs a statutory durable power of attorney and a muggle power of attorney at its minimum for protection. This was a lot. You may feel overwhelmed. The goal of today was not to tell you need to be able to write all of this yourself. We will have a session on how to draft documents, but it doesn't mean that you have to. There are resources available. There are three legal partners of the AMOS partnership. Me, I'm Lone Star Legal Aid. This is my contact information. If you would like to apply for services with my organization, that's how you can get to us. There's also the other two partners, which is Houston Volunteer Lawyers and the Earl Carl Institute. You don't have to quickly write all this down. Ms. Neo will send these to you. But they are also my colleagues and friends, and they are just as wonderful, and they can also assist you with your estate planning documents. If you do not qualify for services, the Houston Loyal Referral Service is a service of the Houston Bar Association. They will be able to provide you with a reference for an estate planning attorney that will be able to do that. These are people you will pay, right? So these are lawyers you would be paying, but they have different fees depending on your situation. I can't tell you how much it's going to cost because, again, individual plan does depend on what's going on. But that is a way to find private attorney referrals. Last but not least is Texas Law Help. This is a wonderful self-help site. It's really good not only for being able to find estate planning, they also have an interactive way where you can just go type in the information and it will give you your medical power of attorney, your statutory power of attorney. You can do a Todd on there, right? So there's a lot of things that you can do there. It also provides a bunch of information on all sorts of areas of the law, family law, consumer, gives you a lot of information what you can do on your own and on a great website. So, but again, Ms. Nia will send you all of that. I always like to end my presentations on a little joke because this is heavy. I try to make this as light as I can and not make it, but this is not a fun topic to think about for ourselves, right? It's a necessary one. But here's my little silly joke, which is Miss Hen is at her attorney's office and she is saying, I want to leave all of my estate to my sister, but if she's not living, then in trust for her eggs. So, if there's anyone who has questions, I know we're right at the top of the hour, but I'm available to answer some questions if anyone has any.
All right. Is everybody's head about to blow off yet with all this information? Thank you. Thank you, Pastor Lewis, for being on this afternoon. Appreciate you being here. Let's see. We want to go back to the question that was asked before that you said you needed to come back to. When
Yeah.
doing a transfer on death deed, do I have to pay to get a new deed with the court or pay capital gains tax? I'm not even sure what that is.
Okay. So no, you don't. It's not with the court. You will file. There is a recording fee, a filing fee when you do a transfer on death deed. It's based on the number of pages, so it's typically around $32 in Harris County, but it does
Mm.
depend on the county. Every county sets their own fees. But most transfer on death deeds will be around $32 to file. A revocation is typically a little less than that. It's around 25, I think. Because it's a shorter document. Um, so no, so it's not something going through with the court. It's just filing with the county clerk. And pay capital gains. No, you don't pay capital gains tax when you file the transfer on death deed. Um, there is what is known as a step up in basis, right? Like the value of the property changes based it like it's not the person doesn't inherit the original value of the property. It's the value of the property, the date of the transfer. But no, there won't be any capital gains tax.
I hear a lot of people asking about that. Well, they say the tax, some kind of stack, estate tax, estate planning tax, income tax, people or inheritance tax. Did you go over that part about the inheritance tax
I
to
did
kind of
not
give?
go over the inheritance tax. I will guarantee that most people do not need to worry about that. I have to think about the number right now, but it's at least I think currently around $4 million before the estate tax needs to do that. But there was a bill in Congress that got passed not too long ago that has increased the estate tax to estates that are worth more than $15 million. So if you have an estate that is subject to the estate planning is tax planning. You do a lot of different things around that. Hope you consider a nonprofit to benefit. But no, for most people, you don't have to worry about the estate tax. It's in the millions right now for the value of the estate before you even have to worry about paying that. And it is something that's paid out of the estate, not paid by the heirs. I know that seems like a difference. It's something without a difference type of thing, but it's the estate that pays it.
Okay. Oh, let's see. Someone said this has been amazing so far, and I hope I'm not skipping because I'm scrolling through here trying to find to make sure. Um,
Oh, there's an interesting question about what happens if a pastor or
yeah,
another faith leader
yep.
has specific information. I don't
But
know what you mean by the question. But I'm suspecting it might have been around HIPAA. Like, I actually don't know if faith leaders are subject to HIPAA. They are probably subject to their own privilege, right? Like they have their own confidentiality protections. But I don't think you can go to a pastor with a HIPAA release and then that be sufficient for them to do that. I think that that's a question for that individual and what the faith requires in terms of sharing that type of information with people outside of the individual who owns it. Was that the question? Was that what was being asked? Okay, good.
okay. Let's see. You talked about Lady Bird deed already, so we
Yes, I
got
did.
that one covered.
I saw that.
Okay.
I'm like, ooh, next slide. Yeah.
Okay. Let me go to my emails here. Um, are you able or how do you transfer property out of a trust?
All the terms are in the trust. Whatever the trust terms say, I don't know how to be able to disperse that property. That's what's going to govern it. So I can't actually answer that because it's whatever the document says
Okay.
is what's allowed.
And legal assistance for creating legal assistance for creating trust, helping aunt and uncle who are elderly on getting the okay. So for the person that had sent me the question about creating a trust or some legal assistance for the aunt and uncle, please reach out to Lone Star Legal Aid for that one. That will forms that are online. Can you talk about those?
Which forms?
Will and estate
Oh,
planning forms, the ones that are online that people find online.
yeah. So I don't ever want to say like good or bad things about anything that you find online. Always just be cautious, right? If you're going to use a document that's prepared by an online service, um, they may or may not be good. I really honestly don't know. I don't have a reason to say not to use one, but you want to be sure that it includes everything that needs to happen. I would definitely recommend that you watch the presentation on how to draft it. Or compare it against the Supreme Court templates that are provided to see like if it looks right or things like that. The things that are probably more important about looking at an online will is being sure that it's fully typed and you're not doing a fill in the blank type of thing. But other than that, it's just kind of one of those like buyer's caution as it is, right? Like vet the document before you purchase anything and make sure it actually does what you need it to do.
Okay. Those are all the questions. I don't see anything on our social media. So if I skipped anything, please feel free to reach out to me and send me a message or send Ms. Jessie a message. I'll make sure that all of the resources that she listed, the contact for all of the legal service partners that we have, all of that information will be included on an email that I send out for those folks that may have joined or tuned in a little bit later and you missed the beginning part. A link of the recording will go out to all the participants as well, along with each one of these documents that she talked about that kind of make up an estate plan. All of those templates will also be included. So I will send out those too. So at least when you're going back to review, then you can at least now have the document in front of you. I was explaining to somebody before that I kind of like for her to go over the presentation so she has your full attention, as opposed to you having the documents. You're trying to look through documents and read and whatnot, and then you may be missing something that she says. So it's a lot easier to hear the information first and then go back and then review it and then watch the recording as you go along. So it makes it a whole lot easier because it's again a lot of information here. We do these sessions in parts, part one and part two, where we alternate. This session will be this is October, so December will be the next time when we'll do this particular presentation again, the first Thursday of each month at 1 p.m. So if you guys want to repeat, or if you have some other questions that you may have thought about, or you want to invite your family members to tune in, I think you guys need to hear this, or let's all sit and talk about this and hear it. That's a great opportunity for you guys to have a group conversation or discussion about what it is that needs to be planned or what needs to happen. Or if you have a group or a congregation pastor that you'd like to invite, that we can come out and do a live session, at your facility or what have you. Be more than happy to do a hybrid session so people can kind of tune in and watch their presentation there as well. So there was another question. This workshop has been very informative. We really do appreciate you guys for sticking around even past the time that we had intended. Let's see, what else am I forgetting? Everything that's going to go out. The calendar is going to go out for all of the remaining workshops that we have for the rest of the month, including the other part of this one, or what happens after, for inherited property and other probate concerns. That session is next Thursday at 1 p.m. And I will include the link of how to go online to go and register for that one if you all want to attend that presentation as well. If there are workshops or topics or discussions that we don't currently offer, there's a link that'll pop up on the screen once you close out of this session, that we're asking for your feedback, for your input on other workshops, any questions that you may have, future presentations, or if you'd like to just kind of tell us, give us your own testimony to say how this information has been beneficial to you. We really would thoroughly appreciate that. We use those in helping with planning for our future presentations as well. So your input is very important and much needed. But again, we want to thank you guys for your support and continuing to come back and listen to the month of service presentation. So we want to give you your afternoon back. So thank y'all very much. Thank you, Ms. Jessie. I know you are parched by now after all of that. So again, if you guys have any other questions, feel free to reach out to me. My contact information will be there. The coffee and conversation over in the OST South Union area, that's going to be with the City of Houston's Department of Neighborhoods. I'll include the flyer for that as well, so that you guys can have that information and potentially want to attend. If you want to come by and meet with some of the partners and apply for the services of Lone Star Legal Aid, or any of our other partners, then you'll have the opportunity to do that as well. But that being said, you all have a wonderful remainder of your afternoon. You take care of yourselves, you stay safe, and we will see y'all